Welcome to csstudents.com, a learning portal for company secretary students. In this presentation, we would discuss the provisions relating to the extraordinary general meetings. Let's first talk about the corporate setup and requirements of having the extraordinary general meeting. Corporate structure is a mix of various parties. At the center, we have the company, then shareholders who fund the company for doing business, then board of directors who have the primary authority to run the business. The board is supposed to work in a fiduciary capacity, in the interest of the company and the shareholders. And the executive management of the company. Executive management includes the managing directors, chief executive officer, etc. They generally work under the supervision of the board. So, the company is a legal entity, wherein shareholders are putting money for business, directors and executives are putting efforts, and benefits are being transferred to the shareholders. So, shareholders are ultimate owners of a company, and, being the owner, they have the primary right to run the company. But, they are mostly scattered and hence, cannot run the company. Therefore, they choose the board of directors to run the company. The board consists various directors, elected by shareholders. The Companies Act provides a clear distinction between the powers of the board and shareholders. Shareholders can choose the directors. They can also remove one or more directors, and also appoint new directors. But, they cannot interfere in the company's operations. If shareholders are not happy with the company's operations, they can change the board members. Although, the board has the primary right to run the company. However, there are certain fundamental decisions, wherein shareholders' approval will be required. Mostly, these approvals are taken by way of holding shareholders' meeting. For certain class of companies, some the approvals are to be taken by way of postal ballot. Still, in most of the cases, companies have to call the extraordinary general meeting to take shareholders' approvals. Additionally, shareholders also have the right to call for an extraordinary general meeting. It's an ammunition in the hands of shareholders to protect their interest in the company if situation arises. Let's try to understand with an example. X Limited is a company with many shareholders. Those shareholders appointed 3 directors, Mr. A, Mr. B, and Mr. C, to run the company. And the board of directors started functioning. After some time, it was found that Mr. B and Mr. C are not diligently working for company's benefit. Their presence as directors started becoming detrimental for the company. In that case, shareholders can call an extraordinary general meeting and remove Mr. B and Mr. C as director and appoint other directors. Now, let's see the legal provisions. Section 100 of the Companies Act 2013 deals with the provisions for the extraordinary general meeting. These provisions are equally applicable on the public as well as private companies. Exception to extraordinary general meeting is postal ballot, which is mainly applicable to listed companies. In case of postal ballot, the company seeks shareholders' approval by sending them ballot through post, rather than holding a meeting. Let's look at the provisions, one by one. Subsection 1 says that the board of directors can call the extraordinary general meeting as and when deems fit. So, if shareholders' approval is required for any particular transaction, the board shall call the extraordinary general meeting. For example, increase in share capital, or issue of securities, or buyback, etc. The board can call an extraordinary general meeting. The subsection 2 of section 100 deals with the meeting to be called by the shareholders. This is one of the most important weapon given to the shareholders. The process to be followed. shareholders would first make a requisition, or we say a formal demand to the board of directors, to call an extraordinary general meeting. While making this requisition, shareholders would specify the matter to be considered in the extraordinary general meeting. Over here, matter proposed to be put in extraordinary general meeting is very important, because other shareholders should know in advance as what matter is to be discussed in the extraordinary general meeting. That matter could be anything: appointment of new director, removing any director, or removing the chief executive officer of the company. The matter could also be to cancel any decision taken by the board. Additionally, this requisition should be signed by the shareholders making the requisition and sent at the registered office of the company. So, if the requisition is not in writing, and it's not signed, or it does not contain the proposed matter to be discussed, the board can refuse to call the meeting. So, requisition has been received by the company. Let's see what happens at the company level. As a company secretary, you have to guide the board for the further process. Once the valid requisition is received by the company, as a process, an urgent board meeting may be convened to discuss the requisition and to call the extraordinary general meeting. The board will also have to decide the date and time of the extraordinary general meeting. Also decide the place of the extraordinary general meeting. The board will also approve the draft of the notice, and that notice will be dispatched to all the shareholders. Now, the question arises: how many shareholders are required to make a valid requisition? Whether single shareholder can ask to call the meeting, or holder of one share can ask for the meeting, or a particular percent of holding is required. The answer is given in subsection 2. Let's look at the provisions. The board shall, at the requisition made by A. In the case of a company having a share capital, such number of members who hold, on the date of the receipt of the requisition, not less than 1/10 of such of the paid-up share capital of the company, as on that date, carries the right of voting. So, the clause A deals with the companies having share capital. But, what happens if the company having no share capital? For example, companies with guarantees. The clause B deals with those companies. It says, in the case of a company not having a share capital, such number of members who have, on the date of receipt of the requisition, not less than 1/10 of the total voting power of all the members, having on the said date, a right to vote. Call an extraordinary general meeting of the company within the period specified in subsection 4. Let's look at the clause A first. Clause A deals with the companies with share capital. In Indian context, mostly all the companies are having share capital. The clause A says that the requisition can be made by the members holding not less than 1/10 of the paid-up share capital, entitled to vote. So number of shareholders is irrelevant. If one shareholder is holding 10% or more of the voting share capital of the company, he alone can ask for extraordinary general meeting. More shareholders can also come together to aggregate 10% or more voting share capital and make a requisition. The important point over here is right to vote. If there is a shareholder holding more than 10% capital, but there is no right to vote is attached to his shares, he cannot make the requisition for the extraordinary general meeting. This may happen in case of differential voting rights shares. Some of the Indian companies have issued non-voting shares. Those shares are entitled for higher dividend, but carry no voting right. Those shareholders may not be in a position to ask for extraordinary general meeting. So, the basic rule is, holders of 10% or more share capital with voting rights can make the requisition. One or more members who make the requisition are called requisitionists. Another important point is, such holder of 10% or more should be on the day when the requisition is received by the company. For example, if Mr. X is holding more than 10% voting shares of a company on 1st January and he sent the requisition, and very next day he sold his entire holding in company's shares, post which the requisition is received by the company on 5th January and on that day Mr. X is holding no shares, the board is not bound to call the extraordinary general meeting on this requisition. So, the holding of 10% or more is not on the day of sending the requisition, but on the day when the company receives the requisition. The point B deals with companies without share capital. Indian Companies Act has enabling provisions to incorporate a company without share capital. For example, guarantee companies. In those cases, members holding 10% or more of the voting power would have right to make a requisition for extraordinary general meeting, and the holding shall be taken on the date of receipt of requisition by the company. Let's look at the timelines given in section 100. Once requisition has been made by the shareholders, the board cannot sit on this and would immediately act on the requisition. Let's look at the timelines given in the Act. Subsection 4 provides for the timeline. As per subsection 4, once requisition is received, the board will have to call the extraordinary general meeting within 21 days of the receipt of requisition. Means, practically speaking, within 21 days of receipt of requisition, the board should decide the time, place and draft of notice of extraordinary general meeting, and should dispatch such notice to the shareholders. For example, if the shareholders courier the requisition on 1st January, which is received at the registered office of the company on 5th of January, the board will have 21 days to call the meeting. Means by 26th January, the board will have to decide the date, time, place of extraordinary general meeting, and send notice to the shareholders. And such extraordinary general meeting must need to be held within 45 days from the date of receipt of requisition. So, in our example, if the requisition is received on 5th January, the board will have 21 days from 5th January to call the meeting and dispatch the notices to all the shareholders. Means by 26th January, the board is free to decide a date of extraordinary general meeting, but bound to schedule it within 45 days from the receipt of requisition. Therefore, in our example, the requisition was received on 5th of January, then, the meeting should have held within 45 days, or we say, on or before 19th February. Let's see what happens if the board of directors does not act on the requisition. For example, if the shareholders have given a notice to remove all the existing directors and appoint new directors, the existing board members, with a fear of losing their directorships, may choose not to act on the requisition, and do not call the extraordinary general meeting. The basic rule of corporate setup is, shareholders are supreme, and cannot be at the mercy of the board of directors. Therefore, the Companies Act has given the powers to shareholders directly to hold the extraordinary general meeting and take the proposed decision for the company. Accordingly, the subsection 4 also provides that, if the board fails to call the meeting within 21 days and schedule the same within 45 days, the shareholders who made the requisition at the first place can hold the meeting themselves within 3 months from the date of requisition. Over here, we need to understand a minor difference in timelines. For the board of directors, the timeline to hold the meeting would start from the date of receipt of requisition. As in our example, the timeline for board was starting from 5th January. However, for shareholders to arrange the meeting, timeline of 3 months would not start from the date of receipt, but from the date of requisition itself. In our example, the date of requisition is 1st January. So, shareholders would wait for board to call the meeting until 26th January. If meeting is not called, the shareholders can call the extraordinary general meeting themselves within 3 months from the date of requisition, means 3 months from 1st January. So for directors, timeline starts from the date when the requisition is received. However, for shareholders, the timeline starts from the date of requisition. But the law has given first 21 days from the date of receipt to the board. In that period, shareholders will not be able to call the meeting, as board's timeline is not yet over. 2 more provisions are applicable if the meeting is called by the requisitionist shareholders directly. First, is provided in subsection 5 of section 100. It says, a meeting by the requisitionists shall be called and held in the same manner in which the meeting is called and convened by the board. Means, all other provisions of the Companies Act shall be applicable, even if the meeting is called by the requisitionists, such as 21 clear days notice. Explanatory statement. Attendance through proxy. Appointment of chairman. Voting related provisions. And the most important, the secretarial standards. As we know that, effective from 1st of July, 2015, Ministry of Corporate Affairs have made 2 secretarial standards mandatory. One of them is relating to general meetings. That secretarial standard shall be followed for the extraordinary general meeting. The second provision talks about the expenses associated for holding the meeting, such as printing and sending notice. Then, charges for venue, where meeting will be held. You may have to book a meeting hall or some other place. Sound system, tea coffee arrangements, etc. Actually, all this should be spent from company's account. But, because directors had refused to call the meeting at first place, requisitionists will have to bear these expenses, and then claim the same from the company. Subsection 6 provides that any reasonable expenses incurred by the requisitionists for calling a meeting under subsection 4 shall be reimbursed to the requisitionists by the company. This subsection also provides that the sum so paid shall be deducted from any fees or other remuneration payable to such of the directors who were in default in calling the meeting. As directors were having the primary responsibility to call the meeting, and they defaulted to discharge their duties at first place, and requisitionists had to call the meeting, company will pay the amount to requisitionists and recover the same from directors who defaulted in their duties. Thank you for watching. Do click on like button below if you liked the presentation. For more presentations, please subscribe to this channel.